Okay,
all right, so we will get started. I'm here. I'm Molly Jane, one of the board members of the ACJR, and I'm here to introduce the moderator, who will then introduce all the rest of the panelists, or they'll introduce themselves, for our ACJR off the record on crypto policy and regulation. So we have Nick here from CoinDesk, policy crypto expert, and you can take it away.
Thanks, Molly. Thanks, ACJR, for hosting this. As Molly said, my name is Nick. I'm a reporter and editor with CoinDesk covering regulatory issues. And I am thrilled to be joined by Matt Liu from SynFutures, Joshua Durham from K&L Gates, and Peter Van Valkenburgh from CoinCenter. Obviously, there is a lot of stuff happening in the crypto regulatory space, both directly impacting crypto and issues that, as I'm sure we'll get to later on, are perhaps adjacent to, tangential to, but still relevant to the crypto sphere. As we speak, House Financial Services Committee is actually kicking off a hearing on the recent banking failures, which is probably going to touch on crypto in a number of ways. So literally, as we speak, this is a topic of discussion amongst leaders. Gentlemen, I want to give you a chance to introduce yourselves and just talk about your work for a minute. Peter, you're first on my screen. Do you want to kick us off?
Sure. I'm Peter Van Valkenburgh. I'm the Director of Research at CoinCenter. For those of you who don't know, CoinCenter has been around since 2014, which makes us like dinosaurs in the crypto policy scene now. And our mission is to educate and advocate in Washington, D.C. and in other government circles about cryptocurrency technologies and about the inevitable policy issues that cryptocurrency technologies raise. And part of our mission is also to educate and to answer questions for the media, because the media, of course, influence policymakers. So happy to be here today.
Joshua, can you continue?
Hi. You can call me Josh. Sorry, I have really bad allergies right now, so sorry if I sneeze or whatnot. I guess I got started in the crypto space back in 2017. During undergrad, I worked for Laura Shin, helping her with the podcast and research. And when I went to law school, I interned for Commissioner Peirce at the SEC. So that was great. And yeah, throughout these years, I guess I taught myself Solidity, and I've just really, I dove into the tech. So I mean, that all said, I'm working at K&L Gates right now, but I have like two more months of law school to finish up, then I'll take the bar in California. So grant me some grace. I'm still in the very beginning of my career.
Good luck with the bar. And Matt, now.
Hey, thanks, Nick. Hi, this is Matt Liu. I'm a partner and chief strategy officer at SynFutures. We do on-chain DeFi derivatives. So I'm based in Singapore, and I come more from a financial as well as technology background in building in this space, and hopefully, building for the long term together with the stakeholders, including the policymakers. Thanks.
Awesome. So, obviously, there's been at least a small amount of news over the last couple of weeks. I would say. I honestly don't know where to begin, but Peter, I want to just start with you, because I know you've been, and your team has been hard at work on a lot of the kind of more philosophical issues, not just the day-to-day minutia, but also the broader impacts of some of the bills and legislation that have been proposed over the last couple of years. What do you see as kind of the big things happening right now, the big issues that the crypto industry should either pay more attention to or should engage more on when it comes to policy and regulation and legislative rulemaking?
So I'd say that starting 2 summers ago with the infrastructure bill in Congress, which became law, we sort of, at least at CoinCenter, found ourselves in a position where the stakes really gotten a lot higher. Up until then, we actually on a fairly fundamental level agreed with most of the policy choices that have been taken in Washington with respect to crypto, especially say on the anti-money laundering front, where FinCEN had clear guidance since 2013 about how those who actually hold customer funds are obliged to follow the strictures of the Bank Secrecy Act, know their customer and all those things. But those who are non-custodial, say miners, stakers, individual node operators, individual Bitcoin users are not obligated to surveil their customers and the like, because they don't have customers, they're individuals. And
I'm sorry, I resisted it once. I can.
Sorry, if you are a viewer, would you mind just muting yourselves? And Joyce, I don't know, maybe you have the ability to mute people who are not speaking.
That's all right. Anyway, so starting with the tax provisions that were passed into law in the Infrastructure Act, especially with regard to the definition of who is a broker in the cryptocurrency space and therefore needs to do third-party reporting. So third-party reporting is like when Robinhood gives you a 1099-K or a form that describes all the trades you made in the past year. They also give that form, of course, to the IRS. So if you don't end up self-reporting those trades to the IRS knows. Third-party reporting is important, however, and I know Coin Center has actually asked for clarity for companies like Coinbase to do that kind of third-party reporting for a long time. But what happened in the infrastructure bill is language which we suspect was basically came from the administration and from Treasury, made its way into the bill to redefine broker to actually potentially cover a much larger number of entities in the space, decentralized exchanges, other non-custodial participants, possibly even extending to miners, software developers, and the like. And it's Coin Center's basic proposition that we have these constitutional rights in the U.S. to speech and privacy. And one of the important aspects of the privacy right is that, unless you're actually giving your information, your private information, to a real third party like a bank or a custodian, you have a right to have that information remain private and only be subject to government searches with a warrant and proper due process under the Fourth Amendment. And so to our perspective, saying that someone who develops Bitcoin software or someone who mines the Bitcoin blockchain should be obligated to collect information about the people who use that software or make transactions on that blockchain is a violation of those Fourth Amendment privacy rights. We're still waiting, actually. So this gets to, I know I started kind of far back in time, but we're still waiting for Treasury to finalize rulemakings on, or at least guidance on how they're going to enforce that broader definition of brokers, whether it's going to include DEXs or other things. And that could drop at any moment now. So I know we've already had a lot of news, but there's probably more news coming, which is good for journalists, I guess, but not so great for crypto folks. And then the other thing I'd say is in that infrastructure bill, there was also a passage that had to do with what's called 60/50I reporting. And this is the obligation of someone in crypto who receives a transaction of $10,000 in value or more, even if it's just in the ordinary course of business, like you're selling like an antique table, you're at an antique store and you take Bitcoin payments and you sell a very valuable table. You have to collect the name, address, and other personal information of the person paying you, and report that to the IRS, actually on a transaction by transaction basis. So not even at the end of the year on your tax return or anything like that. And to us, this is also a violation of Fourth Amendment rights, because this is not a situation where a third party like a bank or other responsible entity needs to know their customers. This is just one person paying another. And so the third party doctrine, which is an exemption from the warrant requirement under Fourth Amendment jurisprudence, we don't think actually applies in an arm's length transaction between two persons. And so you should still have a right to the protection of a warrant before government comes and gets information about the fact that you paid somebody, at least in the US. So we're actually suing the government. We brought a lawsuit against Treasury, arguing that the 60/50I provision specifically is unconstitutional. That lawsuit is pending in the Fifth Circuit. And then came the tornado cash designation, which has nothing to do with the infrastructure bill, but happened not too long after and was another sort of starting pistol shot for government taking a much stronger hand, especially with respect to financial surveillance and a sort of heavy-handed approach to regulating non-custodial and even just robotic entities on the protocol. And we're suing because of the tornado cash designation as well. We're suing Treasury, a different part of Treasury. It's OFAC versus the IRS, but still suing Treasury arguing that you can't add an immutable smart contract to the list of sanctioned persons because it's not a person, nor is it the property of a person if it's truly immutable and the original authors of the smart contract don't retain the ability to update or change the operation of that contract. So, this has been huge for Coin Center because for years we were an education organization focused on doing briefings on the Hill, one-on-one briefings with members of Congress who are interested, or big group briefings, what is Bitcoin? We still do that, but starting in 2020, 2021, we started pivoting, either gearing up or actually bringing legal challenges, pivoting to being more of an impact litigation organization, because we're finally seeing policy being made that's not sensitive to the nature of the innovation, that's not sensitive to constitutional rights of the users of these technologies. And given that our only option is to either lobby Congress to repeal past made laws, or get control over agencies that are over broadly interpreting their laws like OFAC, or to just fight it out in court, which is, I think, actually the more promising avenue for obtaining real justice in the shorter term.
So, I remember covering the infrastructure bill and that whole, thing when that happened. It felt like weeks. I looked it up later. It was actually, I think, just a week or two in August of 2020. Felt like a couple months, really. But, one of the things that kind of struck me then
it
was...
felt crazy for me because I was actually on paternity leave with our first child being born, right timing. Before. And so, well, it was lucky for me because actually Jerry, my boss, the executive director of Coin Center, is really good about parental leave and was like, I might need you occasionally, but I'm going to honor your leave. And so I tell people that my colleagues at Coin Center got far less sleep in the first few weeks of my having a newborn child than even I got, because they were taking meetings at all kinds of weird hours of the day.
I believe it. There was a lot of late nights covering that. But one of the things that really, struck me at the time was, there was a lot of momentum to amend the provisions, at least some of the provisions that the crypto industry found problematic. Even the lawmakers who introduced the bill supported changing it. But at the end of the day, nothing was changed. The bill that was passed was not the initial version, it was the second version, but it was still, seen as problematic by the industry. It seems like, once there is this kind of inertia with rulemaking or legislative policymaking, it's hard to, shift it. What are you seeing as, you mentioned a couple avenues, the courts, working with regulatory agencies, but what do you see as, realistic ways that people, such as Coin Center or groups like Coin Center, can take to have an impact on this kind of process?
Yeah, and I'm glad you brought up the fact that there were a lot of members of Congress, and even in the Senate, where it was coming down to the wire, who were ready to go to bat for us. And we did get improvements. Early version of that language actually specifically identified things like decentralized exchanges, and that ultimately got fixed. It was still too broad for our liking, but you're right. We had a lot of members of Congress go to bat for us, even like Democrats like Senator Wyden, Republicans like Senator Toomey, huge champions. And I'm glad you brought it up, because I think there's a real contrast with the way Congress looks today. And I think a lot of that, it's not that we have an outright hostile Congress to crypto, but compared to the infrastructure bill fight, when we had a lot of allies, some of those allies are gone. Unfortunately, Senator Toomey didn't want to stay on. I can't entirely blame him. I think I'd get tired of being a senator after a while too, if I ever had the privilege, and I don't want it. And then, some of our allies, I think, have gotten a little gun shy. I don't blame them at all, because, we all know what happened in between the infrastructure bill fight and where we are today. You have the explosion of a lot of really scammy, effectively fraudulent projects in the space, like the Terra Luna stablecoin. And you ultimately have the explosion of FTX, which was seen as this honest broker in DC. SBF was coming, bringing donations to candidates or to members of Congress. He was coming to briefings. His team was all over recommending certain changes to legislation. And then it turns out he's just running a giant Ponzi scheme like Bernie Madoff, with all the accounts of customer funds intermingled with his own private investment fund. At least that's what it seems like happened. I don't mean to allege any specific wrongdoing without knowing for a fact. I'm just reading the news. So, if you're in Congress and this was the face that you were seeing, I mean, hopefully you were also seeing Coin Center still, but like that was the face of the industry. What motivation do you have to stick up for our interests, even if you somewhat believe like that there really are important technological and constitutional interests at stake? It's a liability now to be associated with that class of people.
Right. I want to bring Matt in here because I know you've been also talking to less US centric, but all, more international agencies. Are you seeing a similar kind of, let's say, cooling off of, friendliness from policymakers in the wake of things like FTX?
Hi, yeah, thanks, Nick. So my experience has been a little bit different with more like a supranational regulatory bodies or like with international regulators. So like, I have been talking to like some of like my friends who are in these regulatory bodies since, we started to build this business because we truly believe that there are a couple of points in DeFi, in decentralization, that actually work in line with some of the regulators' goals, like transparency or prevention from embezzlement of fund. So then my experience has been, I've been like talking to some of these friends for over a year, but it was only after the FTX thing that some of them really wanted to know more about, how DeFi works. Yeah, why this could be better. Hence, last December, I was in DC, talking to the MCF group at IMF. I think they had a group of 20 different representatives from different central banks. I remember there wasn't a US regulator there, but there were like representatives from Bank of Japan, and then people from the Central Bank of Ukraine, etc. And it was pretty friendly conversation I had by basically showing them the differences from a like TradFi, such as like a banking, and then CeFi, like a centralized crypto exchange, and then DeFi platform like Uniswap or like us, like SynFutures, because we came from these institutions. I myself used to work in like bulge bracket banks, and then moved to CeFi and then started DeFi. So we were kind of, I would say, in the right shoes to compare the differences from a business perspective, right? So of course, in terms of like the regulatory language or the framework, I think we may not, like people like me may not be the best person to comment on the drafting and the process. But I kind of feel the regulators I talked to were very open and friendly to actually talking to business to understand, what are some of the directions we could potentially be working together. Some are already obvious, right? So like transparency or, prevention of embezzlement of fund. Others, like the topics like KYC, I think, we kind of also reached some, agreement that, this is going to be a topic that's going to be here for a while. And then, both sides need to work and bridge somewhere in the middle, right? At the end of the day, look, today they're just too few users in DeFi. Yeah, it's not only because the product needs more improvement, but also because if you ask me whether I push my product today to 100 million people, I would be a little bit scared. Yeah, because I myself, I'm a user of many products, and I need some sort of, you call it like endorsement or some comfort level, and this is, I think, a critical part for blockchain, crypto, and DeFi to really go from this like a small group thing to the mass market. So I can't really comment on specific countries, but I kind of feel the international regulators are pretty open.
I strongly agree with what Matt just said, actually, and I just want to clarify that if I sounded very pessimistic and dark, it was mostly with regard specifically to Congress in the short term. Things can get better in the longer term. And I'd make a distinction between Congress and legislators who have to have a general base of knowledge and therefore usually can't have the specific knowledge of like what is DeFi versus CeFi and what are the nuances there, versus regulators who make it their job to understand the technology that they're regulating. And we really do still have some excellent regulators in various US agencies who do actually understand the distinctions and understand that, overreach, trying to bring the hammer down on DeFi is bringing the hammer down on the part of the system that actually wasn't blowing up and might actually deliver technological answers in the long run to things like transparency and theft of funds and like that. And so, this job, we face many different, parties that we have to educate, whether it's a member of Congress who can only have a cursory knowledge because they're dealing with the entire corpus of US legislation, or whether it's, someone at Treasury or at FinCEN who has to deal with specific anti-money laundering policy. The staff experts in those agencies are still very sympathetic and understand the technology. The political class doesn't have always the time to have a nuanced understanding and respond to crises. And sometimes those responses are a little aggressive. And sometimes they're warranted, though, if you look at how bad the fraud in our space was over the last year and a half.
Absolutely fair points. Speaking of the fraud, and I'm just going to open this up to the panel here. Let's face it, there were some pretty bad blowups over the last year. Horrendously bad, ones that I think caught a lot of people by surprise. What are some of the not just reactions, but also some of the ways that you draw that distinction between, okay, FTX allegedly did all of these things where they commingled funds and invested customer funds into personal uses and land, real estate and things like that, versus projects that are chugging along and trying to do, the actual mission the way, that they claim to do in a way that doesn't allegedly defraud their customers.
I can jump in. I don't want to dominate the conversation, but a lot of it is just explaining, as Matt was explaining, the fundamental differences between CeFi and DeFi, because there are also good versions of CeFi. I don't mean to suggest that everything should be DeFi, but at the very as a first pass, we need to make sure that policymakers understand that some people are, by virtue of the really good parts of the technology, incapable of blowing up in the way that FTX blew up. Like the Bitcoin protocol as a whole, where an individual holds their own coins, you don't have this sort of systemic risk of a single counterparty that, it is trusted by a number of parties to secure money. As far as like, how can we rebuild trust in CeFi? I think in the US, at least, we've had a sort of very convoluted regulatory regime for CeFi. We've had the SEC arguing that a lot of these tokens are securities, but not bringing an enforcement action, at least not yet. It might be right here, right now, potentially with the recent Wells notices that have been given out, but not bringing enforcement action for operating an unregistered securities exchange. And that's a strange mismatch. If the SEC really believes, and Gary Gensler will often say, that 99% of the tokens out there are securities, then it doesn't make sense why there are these large, above board, legally operating companies making markets in these things and not registering as a securities exchange or an ATS, which would be the regulated form for a securities market. So that is an element of regulatory uncertainty. There's also the fact that when they do go get regulated, companies like Coinbase and Kraken are faced with strange choices, like, am I supposed to be a money transmitter and register in the 53 states and territories that license that activity? That's a little odd because money transmission regulation was built during the days of like Western Union and MoneyGram and the corner store where you'd buy a money order to pay your electricity bill. This activity has consumer risks, and the activity that Coinbase or Kraken are doing also has consumer risks, but they're very different risks. I mean, actively trading a handful of cryptocurrencies is wildly different than paying somebody to pay your utility bill with a money order. They are completely different. So that's a weird regulatory mismatch. But a lot of companies were like, well, this is the regulatory form that seems available to me, so I'll take it because I want to be regulated. I want to actually follow the law. Then there's also the state charters and the state trust designations, which sort of became the heavier duty version of that regulation. Go get a trust charter from New York State. And there's questions about then how does that interact with the jurisdiction of other states? Do I still need money transmission licenses in the states that I don't have a trust charter from? And how does that interact with the federal government's jurisdiction here, for example, with the SEC or with the OCC if they were to start chartering federal banks? So federal non-bank financial institutions that do these sorts of cryptocurrency activities. So if this is confusing, because I've given a very fast and loose summary of the regulatory avenues available, it should be confusing. It's confusing even to people who've studied this for a long time. And this means that if you wanted to be a really good faith actor in the space and get regulated and have heavy duty consumer and investor protections, there wasn't an obvious path. You did your best. And that kind of uncertainty means that there's this flexibility, if you will, for bad actors to come in and pretend like, oh, well, we're trying to comply. We just don't know how to comply, even though they don't really want to comply. They're actually, like, as alleged about FTX, and seems likely, they're happy that there's this uncertainty, and they're happy to do all kinds of questionable things about offshore entities and moving funds and things like this, because there's no visibility into their books, because there's no good basic prudential regulatory framework for them. So, like, we actually have to convince regulators in order to regain their faith that they do need to do more, but they should do more in a sensitive way that looks at the actual unique qualities of these companies and addresses the risks where they exist. And they actually have to regulate. Like, I can't tell you how many times I've heard from regulators who are not helping that they don't want to put the imprimatur of legitimacy on this industry, and therefore they don't want to extend their regulatory forms to companies in this space. That's a disaster, because you can't just pretend that the companies won't continue to exist then. They'll continue to exist, and customers will continue to use them. And then you're just failing as a regulator to do your job, rather than, this thought that by doing your job, you'd be convincing more people to use crypto, and that would somehow be bad, because people are going to use crypto no matter what, because it's, in many cases, very good technology.
Right. I mean, what's interesting is, I think we've also seen that kind of play out to an extent with Sam Bankman-Fried and the head of the CFTC, Chairman Ross Benham, and the SEC with Chair Gary Gensler, where, in the immediate aftermath, I think there were a lot of people saying, oh, SBF was great friends with Gensler and or Benham, and so, these agencies endorsed FTX, and now look what happened. So I think I don't think that's an accurate summation of reality, but I think to your point of that being a fear from regulators, that did happen to some small extent after FTX blew up. But I want to switch gears a little bit to another aspect of this kind of trying to read through the tea leaves. Josh, you worked on a paper about for a sale doctrine surrounding NFTs in particular. Can you just quickly talk us through that, and then where, I guess the big question is, what kind of legal theory do you have to go through to even figure out that kind of conclusion?
Awesome. So, well, we've been discussing how, like, blockchain really, as an internet technology, really changes the way we apply our laws and forces us to rethink, like, should we make new laws and regulations? And yeah, we usually see that with financial regulations, securities, commodities, financial services, but we also see it with our intellectual property regimes. So particularly with our copyright laws, and actually it really every, like, patents and trademarks too. There's this court doctrine called the first sale doctrine, that basically says whenever you buy really anything that has copyrighted material on it, or has a patent, or there's a trademark on it, the moment you buy that copy, it's your personal property, and the IP holder can't restrict you from reselling it or, giving it away to a friend or even, destroying it. So, but like with the internet, there was, I guess the internet made a loophole in the first sale doctrine saying that, with digital media, it really doesn't apply. And that was due to it was before blockchain technology existed. So when someone sent you a file, like a picture or something like that, they received that file of the picture, but you also still retained your original copy. So there's a double spend problem. So our copyright, the copyright office was saying, well, we're not going to allow the first sale doctrine to apply to that because it was an unauthorized reproduction. There's a double spend problem. So that's just setting the stage. So applied to NFTs, really any secondary sale of an NFT is an unauthorized sale. So does that all make sense?
Yeah. I mean, fairly straightforward so far.
Yeah. Okay, that's the issue that I addressed in my paper. It's just yeah.
Josh, I had a question. I haven't read. I really do want to read the paper because I used to be very interested in copyright law before I got into crypto. And I agree with your characterization. I guess one question I had is, do any of the NFT projects that issue NFTs create some sort of bespoke license that suggests that the current holder of the NFT does actually hold the copyright? Because I feel like that would be a way out, right? Would be just be transferring rights along with the token.
Yeah. I thought about that, and I mean, I guess I even wrote about this. There's right now, even if there is a license like that, I mean, there probably are, saying that you have the right to resell it and whatnot. And most licenses are actually unenforceable in and of themselves because there's no click wrap agreement. Whenever you go on OpenSea and you buy an NFT, you're not presented with the license to that IP, saying I agree to this. You're really just purchasing it, with your wallet. So
what we need is for the punk to have a pixelated version of the terms of service right next to his head. Just to be clear, if you buy me.
Oh yeah, people are working on that, but it's without even an enforceable license, the first sale doctrine should apply as a backup, and really that's what I'm talking about in my paper. It's blockchain technology resolves the issues the Copyright Office once posed with a digital first sale. Whenever you buy an NFT, you're in no way reproducing that NFT, so you're not infringing the right of reproduction at all. So it's yeah. And I really just dove into the tech as well. To reproduce that, to reproduce an NFT, you'd have to fork a whole blockchain or something like that. Or even on the smart contract level, whenever you call the transfer function or something like that, what you're really doing is going to the smart contract and saying hey, me as the owner of this NFT, change the owner to this other address. The NFT isn't even moving. So yeah.
So just to grab a couple specific points out of that, I guess first off, there was a lot of discussion in I want to say 2020, 2021, where when you're buying an NFT, what you're really buying is a digital receipt for whatever address on the blockchain that the actual NFT is mapped to. Would you say that's a fair characterization?
Well, yeah. I mean, it definitely just acts as a deed, really, and the media could be hosted somewhere elsewhere or on the smart contract itself, but it really does act as a deed. Yeah.
But is that distinction really well understood by the majority of people who buy NFTs, or is that something that either the issuers of the NFTs or platforms like OpenSea, is that something they need to make more clear? if you're trying to buy an NFT with the idea that, oh yeah, I can resell it or do whatever with it?
I mean, I really don't think that's a huge issue, because like if someone is selling an NFT and they're presented with this image and it looks like they can buy and sell the image. Like if you're saying that, well, you're not really buying the image here, but you're buying a token that tracks the ownership of it, and you don't really own the image. Like that's almost a deceptive trade practice. So that would be, that implicate, all these like FTC regulations and stuff. So
Gotcha.
I like to approach it as like when you buy an NFT, you're buying a copy of that media, and your ownership is like verified on the blockchain. Yeah.
Gotcha.
But
there is an audience question on this too from, I believe this is Mitchell Moose, just says Mitchell, but he's asking, is this a real problem? Theoretically, it seems like there's a conflict, but are we seeing enforcements or disagreements where sales or reproductions are resulting in lawsuits?
Yeah, so I spoke with like very senior IP attorneys and like NFT attorneys, and they were telling me that like this whole time they were still unsure about like how the first sale doctrine applies to NFTs. So I don't think this was a huge issue because people just didn't understand it yet. So I mean, if lawyers didn't even know about it, like how would NFT creators like enforce the first sale doctrine and stuff. So that, I guess, like a real big part of my paper was just explaining this issue and how it's real. So I had an NFT project even like offered to create a first sale NFT collection and have that be the grounds for some case. But yeah.
Gotcha. And then another audience question from Diana Aguilar. What are the language loopholes that NFT projects can hold onto today to avoid legal consequences in the event of a rug pull?
Wait, can you say that again?
Like, what can NFT projects do? What stipulations can they make to avoid any legal consequences if there is a rug pull somewhere down the line? I assume either the issuer or by the listing platform, right? She nodded, so yeah.
I mean, I guess I'm not. I guess I just don't understand the question. Would the NFT issuer just be selling these blank NFTs or something?
Yeah, you want to unmute real quick and.
Yeah, just to explain myself real quick, because this is mighty interesting. So, for example, I am from Latin America, and in the case of NFT projects, what we're seeing here is that they mostly avoid being specific in the way that they set expectations for the community, and we see that in their websites and in the way that they address the community. So later on, when we see rug pulls, for example, there was a huge case involving a comedy club, right, in Venezuela. And when lawyers went on the help of the community, most ex-holders completely lost their funds, over $400 per piece. They found out that in the website, there are promises of possible benefits, for example, but not actual benefits. So stuff like that, like you could maybe expect this to go up in value and then treat the community for over months as if everything that they do is going to help this raise in value. So they keep on engaged, but then they made the rug pull, took all the money, and the community was left without knowing if they were part of an actual NFT project or a private project that took advantage of them. So in this case, the use of language was super helpful.
Yeah, I don't know which jurisdiction is this in Latin America?
This was made from Venezuela, but involves Latin American community, yes. The founder is based in Mexico, so they couldn't be held within any jurisdiction.
So I think what you're describing is sort of like a very real problem in simple fraud claims with respect to contract law, where the promoter wrote a contract that limits their liability because it says, well, we never actually promised anything specific, right? We just had sort of vague notions that we were going to promote this thing, and there'll be some tweets somewhere that like encourage people to feel like they're going to get rich off of buying it. Anyway, the long and short of it is pursuing it in like a simple contract claim might be difficult because they sort of like covered themselves in the way they described their project. Pursuing it as an unregistered securities issuance might be a more promising avenue, though, because securities laws, at least in the US, and this is why I asked about the jurisdiction, but I'm just in general not a legal expert in Latin American securities laws. But in the US, we have this issue, and I think this would be actually a good usage of the fairly broad and flexible interpretation of what is a security in the US, because if what you're selling is something you claim to be just sort of an artwork or a sort of commodity-like product, but there are enough statements that you and your co-promoters have made on the record that lead the purchasers to believe that you're going to take efforts on their behalf, even if you don't specifically describe those efforts, then those sort of veiled promises, along with the sale of the asset, together constitute the offering of a security. And then you can go after the promoter, not for failure to make good on their vague promises, but simply for failure to register as the issuer of a security. And so, like, again, I don't know the specific Latin American law at stake here, but this is why securities laws can actually, be a force for good. I know in the crypto community, lots of people complain about sort of unclear or overzealous enforcement of the laws. But in the case of a simple scam where obviously the promoters were making everyone believe that they were going to get rich and then they walked away with all the money, I think that's a very fundamental example of securities fraud and can be investigated as such, both for failure to register and for fraud, because the securities fraud laws are a little bit broader than a simple contractual fraud claim.
I kind of want to jump on this idea of cross-jurisdictional issues, though. Obviously, the whole point of crypto being this, in theory, borderless, decentralized thing that anyone can access. Are we seeing lawmakers around the world and regulators around the world have been, clearly aware of this for a while, but are we seeing, more acknowledgement of, that particular nature in some of the rulemakings that we're seeing? Matt, I know you've been, obviously you've actually had to deal with some of this cross-jurisdictional stuff. Have you seen, any acknowledgement, any, efforts to touch on that?
Yeah, I would say there's a big need for the, like I said, basically like policy harmonization, consistency among different regulatory bodies in different countries. But I think at this moment, like realistically speaking, there are actually very few that are really in place. I think for one, this is because I think different countries, different regulators still have very different understanding about this technology, right? Some are more hostile, others are more welcoming. It's not as easy to understand as, let's say, the equity market, right? So everyone understands that and kind of form similar securities laws, around that equity market. But this even like what we have seen, right, in certain jurisdictions, some people are still arguing this is a commodity, others say, this is securities. So, even within the same country, that the understanding are different. But I would say, in a couple of years' time, I think the understanding by the regulators would come to the same level. Why would I say this? Because I've been talking to like some regulators or like these stakeholders 5 years ago. Started first on the education of blockchain technology, and then on enterprise blockchain, then public blockchain, and now DeFi. I have a genuine feeling that the knowledge base of, I would say, generally speaking, regulators and other stakeholders have increased a lot in this past 5 years. There are a couple of factors, of course, right? So for one, I mean, agree or not, this whole speculative nature of crypto really got a lot of people to learn about blockchain technology. I mean, of course, the other reasons, right, that the industry got so big that it becomes impossible to ignore. But yeah, I think, you know, this harmonization will be critical, but still we haven't seen much at this moment. But the good part is I think through my conversation with the supranational regulatory bodies, I think they're trying to align on like a policy guidance or direction perspective to individual countries or individual regulators in terms of like regulatory advices, right? But of course, you know, these are not the people who actually make the actual laws, the regulations. But the good part is, you know, this influence can, I would say, is a soft force that will bring everyone to the same page one day.
I'll just briefly piggyback off of that too. Like at least in Southeast Asia, you're seeing like an immense, you know, interest in crypto from like in the Philippines, Singapore, even like Vietnam. And like these countries have really taken like pretty different approaches so far. Vietnam has been very permissive and hasn't issued a lot of like guidance or laws, but you know, Singapore is like very advanced in its laws and regulations around crypto. But like, so like this interest is gonna, yeah, like force regulators to really like evaluate how we should, you know, make new laws and whatnot about this. So yeah, it's just great.
Awesome. So I want to jump to some of the audience questions in the 15 minutes or so we have left. One audience question that came in, I think prior to this webinar even starting, this was part of the registration, I believe. I see so much about policy regulatory efforts by the blockchain community in Washington. What's being done at the state level? And Peter, I think, you know, maybe you can kick off this one.
Yeah, I mean, when CoinCenter first started in 2014, we probably did the majority of our work at the state level because there was a fundamental question as to, you know, to which entities in the space are money transmission licensing laws obligatory. So, you know, there was this open question whether it's just the Coinbases of the world, just the custodians, or, you know, just somebody running a node or things like that. And we commented on the bit license, which was going through in New York at the time. California floated a bunch of bit license-like regulatory acts. And we said, look, you should just focus on the low-hanging fruit as far as consumer protection. And those are the people who actually hold Bitcoins for other people and will lose them, you know? And by and large, I think we were fairly successful. In general, most states reasonably interpret their money transmission licensing statutes to cover those activities, which is important because you don't want those businesses running in unregulated fashion, because then you get things like FTX, and not attempt to use those laws for an overbroad purpose to just like, you know, try and regulate someone who's mining or things like that. The federal government was sort of slower on the uptick here than some of the states, at least compared to, say, the New York Department of Financial Services, with the exception of Treasury. But, you know, the securities, the SEC, Securities Exchange Commission, got really active subsequently. Other parts of Treasury, like OFAC, got really active. And so we just have finite resources and we have to direct them where we think we have the biggest impact working on good policy. And so we have pivoted more from state outreach to the federal government. The other issues that are still pending at the states are sort of, they're more niche. And so I would like to see more dedicated, you know, sub-industry specific trade associations focused on those issues. One big one, obviously, is mining, because miners tend to use electricity behind the meter, sometimes because maybe they've purchased an old coal power plant or a hydroelectric power plant, or they've got a deal with the local utility company. And for, you know, obvious reasons, state legislatures and state utilities regulators are interested and sometimes concerned about that, because you've got a big new type of customer that demands a lot of electricity. It can upset grid stability, but it can also be used in, potentially to enhance the grid by creating a steady demand load that can balance fluctuations in things like solar and wind power. And so there's some very real and nuanced policy questions there that, again, I think would be better addressed if there was sort of a more unified industry voice for Bitcoin miners in the US, for example, because that's very much a state-by-state thing in the US. There's also a lot of like sort of, like you think of this like sword of Damocles hanging over our heads. There's some interesting things that states have power over that they haven't necessarily tested or tried to enforce. Every state has its own securities laws in the US, and they're called blue sky laws. And so just as much as we have uncertainty over which tokens are securities at the federal level, any particular state can also allege that a token is a security under the unique but often similar securities laws of the state rather than the federal jurisdiction. Hopefully that gives you a roundup of sort of my thinking about state policy. There are some very important issues. I don't mean to suggest that there aren't, but at least from CoinCenter's perspective, we've had to focus on sort of the bigger elephant in the room, which has become federal policy.
And
yeah, I know. Oh yeah, go for it.
Yeah, at least in terms of money transmission, you see states saying, well, crypto is explicitly, they don't have to register as a money transmitter, and other states are like, yes, if you do crypto, you have to register. And at the same time, a lot of states are, just admitting that we just don't understand blockchain technology. We don't know how best to apply our laws. So they're, they have these regulatory sandboxes that encompass blockchain technology. So it gives regulators the chance to, really understand the technology and hope and like fashion new rules and regulations around it. Yeah.
Gotcha. So, just one quick example to, what Peter and Josh just said. As we've seen, the New York Attorney General's office is suing crypto exchange KuCoin, and among its allegations is the allegation that Ether is a security under state law. How that's going to play out, I think it's probably too early to tell. Whether that becomes any kind of precedent, again, same. It's in state court, not federal court. It's going to be. So far, it looks like it's going to kind of go towards like an adjudication process rather than like a full trial. So it's odd, but also that is the kind of thing that, I imagine everyone here is paying attention to, because that could have implications beyond just this one case. So another question that we got, and this is from Dylan. I'm actually going to expand it a little bit. He's asking specifically about how to speak to the United Nations to make sure they understand. But, I want to think just, this is a good question generally. If you're trying to interact with, regulatory agencies, supranational agencies, entities like UNICEF and the World Health Organization, how do you do it in such a way that you don't come off sounding like Wikipedia article on crypto? What's the best way to interact?
I mean, I have a certain fondness for legal academia and sort of more philosophical legal analysis, and there are fundamental questions whether international law even is law. So like because these institutions they're supranational, so when is a decision that they make binding on an individual within a member state to one of these organizations? These are really hard questions. What I would say is generally with regard to if you're thinking about like you're concerned about global harmonization of crypto policy or certain global guidelines issued by certain organizations, just try and get involved. A lot of these organizations actually have, as part of their mandate, a duty to consult with the private sector when they issue recommendations for their member nations. So to take one example, the Financial Action Task Force, or FATF, is it grew out of the OECD, but it is sort of it's an independent member-driven supranational organization whose mission is to harmonize anti-money laundering policies in all of its member states. And they don't exist by treaty, so it's not like the US is bound by treaty to obey the anti-money laundering recommendations of FATF, but they have a lot of soft power because they can effectively, they curate, if you will, a gray list and a black list of member states or rogue states that are not compliant with the FATF guidelines. They're not forcing companies in their borders to know their customers and things like this. And if you're on the gray list or the black list, you're going to have a devil of a time getting any access to international financial rails like correspondent banking services. And so that organization wields a surprising amount of power by threatening to add member states to the gray list or fail them in their mutual member reviews, because basically they become an international financial crimes pariah. And that organization, FATF, has issued recommendations on crypto and what member states should be doing as far as crypto companies in their borders collecting customer information and filing suspicious activity reports and the like. They do have input from the private sector. They do an annual private sector consultative forum. I was lucky enough to get invited to actually speak at the forum as one of the panelists, but to my knowledge, anybody can, if they ask, attend. I don't think there's actually like a barrier. You don't have to be invited. You just have to ask if you can join. So these are the important sort of. It's just hard to know that even exists. Like, it's my job as at a nonprofit that focuses on government policy to find out that things like that exist and to find out that actually, I can go and join and speak or have my voice heard. It's difficult because a lot of people don't even know that FATF exists until they start looking for the specific global extra legal organization that actually handles this niche problem. On securities laws, I was talking to a colleague recently who works with IOSCO, which is the International Organization of Securities Regulators or something like that. I actually don't know what it stands for. And they do a similar job of coming up with global standards for the way securities regulations should ideally be enforced. What kind of disclosures do we want from registered companies and things like that. So there's all these different bodies. They're often not just the UN. We think of like, what is international law? It's the United Nations. The United Nations has some very important functions and some very important sort of sister or child organizations, like the WHO, I believe came out of the UN. But there's also a lot of these sort of ad hoc or standalone organizations like FATF and IOSCO. There's also international standard setting bodies, which are really important, like ISO for like, what is the right way to do key management for crypto custody and things like this? Like, could we have an international standards body come out and print, sort of authoritative best practices and things like that? So it's a mess because it's not like your local jurisdiction where, I have my congressman and he's in Congress and he passes laws and then there's the executive branch that enforces them. It's like, well, there's a whole world of somewhat authoritative bodies out there that try and harmonize international policy on discrete issues, and you've got to find them and you've got to influence them if you want to have your voice heard. It's tough.
Yeah, Peter, I was second with your opinion. The most important thing is getting involved, right? At the end of the day, there are many these regulatory bodies, supranational entities. And then they're everywhere. So finding the way in, right, getting involved is not only helpful, right, I think for the industry, but also helpful for the regulators and the supranational bodies themselves, right? During my experience dealing with them, I think they're very eager to learn about the business side view, not only because they want to make better regulation or more advice, but to be honest, right, when they speak, they also want other people to think, okay, these are, we not only understand from our own perspective, but we also understand the business. And that's I would say, a very, very important impression. Many of them are, well, actually need. Yeah. So yeah, I mean, getting involved is helpful for both sides.
Gotcha. One last, it's not really a question. There's a question in here. I'm going to summarize what Phil wrote because we have a minute left, but is there a possibility that the crypto industry or companies within the crypto industry projects can make their case for their existence in such a way that regulators are going to look at it and say, okay, yeah, this makes sense and this works, and we're going to, not be very overly, cautious and concerned about what you're doing. Phil, is that a fair summation?
I could start off with this.
As he hunts for the mute button while his printer is loudly going off in the background. Yeah, I mean, that's fair. I mean, I think the main issue that we're running into as an ecosystem is that we have an audience that doesn't really care to understand it. And that seems to be the inch-high curb that we keep on running into, right? Is the notion that what actually does it take is, I guess, the best way to condense it.
So when we advise our clients, at least every time I've been there, we always say that, these are really new issues, and this is a new technology, and sometimes our laws don't apply very well. We have to do the best we can, but at the end of the day, like, if there is some gray area with laws and regulations, you have to be giving, like, making a legitimate, great product. You're not exploiting your users at all, and you're doing something useful with that's making society better. So at the end of the day, like, if a regulator sees that, they're gonna be very uneasy about prosecuting you for something very technical or procedural if you're a legitimate company.
You have to close off, but Matt, Peter, do you want to just add closing thoughts based on that?
I guess I'd say I do love the Upton Sinclair quote, Phil. That's one of my favorites. And it kind of cuts both ways, though, because I mean, I think, I guess for people who can't see the chat, the quote is, it's difficult to get someone to understand something when his salary depends on his not understanding it, right? And it's unfortunately not wrong. And I think it cuts both ways. Unfortunately, in the crypto space, a lot of people who hold crypto and own a lot of crypto seem incapable of realizing how bad crypto has been at actually, like, solving some very real world problems, despite the real promise, the actual real promise of the technology. And, we want a lot from regulators. We want clarity on something that's very hard to give clarity on. Sometimes people come to Congress and they say, oh, I just don't want to have securities laws. It's, they may not realize that's what they're saying, but they're often saying, like, well, because I'm doing it with a token, it shouldn't count. Like, that's nonsense. You can't come to Congress and ask for that. And so I think, like, the crypto industry in a bear market needs to have one of these come to Jesus moments where we're like, look, are we building the right things? We should probably make sure that, like, we're building the right things and using this technology for good. And hopefully there are some better use cases we can go share with Congress, because if in another 10 years, I still can't go to Congress and say, this is how an ordinary American is going to actually improve their lot using cryptocurrency, it's going to be very hard. Like, right now, CoinCenter's mission has always been, we want to preserve the freedom to innovate, because just like in the early days of the internet, you would have never been able to predict all the good things that came out of the internet. And so we got to keep that door open. You can only keep saying that for so long without saying, here's an actual good thing that's come out of it. And we can always point to, say, financial inclusion with respect to nations around the world who have hyperinflationary currencies, like Argentina. They're having USDC able to be a method of payment for your cab or your groceries is a huge benefit. Or making donations to the war effort in Ukraine when the banking system collapses. Like, that's a huge benefit of the technology, but it's not domestic. It's not related to, like, the bread and butter of US politics, which is, what are my constituents able to do better thanks to these new tools? And so until we have those answers, and ideally some non-financial ones too, like, we've kept talking about how we'll have decentralized identity on these systems, so people will be able to own their own data online. Until we have, like, those answers, it's going to be very hard to convince people in government that this is a technology worth standing up for. Anyway, yeah.
Coming down to the kitchen table issues, basically.
Okay, any last thoughts? And then Molly, yeah, I know we are a little over time. Matt, real quickly, anything?
I'm good. I mean, it's very glad, to join everyone here today.
Awesome.
Yeah, thanks.
Well, thank you, Peter, Matt, and Josh for joining us. Thank you, Joyce and Molly and ACJR for hosting this. And Molly, I'll throw it back to you.
Thank you all for coming. That's all. So great.
Thank you.